Eastern Michigan settles Julia Ward's case. This is what I'm going to be talking about on my PowerPoint slides, and it goes like this. Okay, it's that the summary begins. The case began in 2009 2009, when the then student Ward began her practicum at EMU. Upon reading the file of a client to which she was assigned and finding he had previously been counseled about his same sex relationship, Ward, a conservative Christian, notified her supervisor that in accordance with her religious belief, she would not be able to counsel the client and needed to refer him to someone else. Ward's supervisor counseled the counseling session and scheduled an informal review. She was told to set aside her religious belief and was immediately kicked out of the counseling program. In my opinion, I believe that in order to become a good counselor, you have to counsel in all aspects. And I am pretty sure it made Ward a little uncomfortable, but you are helping clients in struggling situations. In modern times, suicide is very common, especially in gay, lesbian, and same-sex culture, because they have to deal with being stereotyped all the time. The chance to help get through these crises is to seek some counseling professional help. I had an uncle that was gay, and I knew what he went through when it came to being that way. My uncle struggled tremendously, so I understand what counselors should put their differences aside in a situation like that, because even though you have religious belief, you can still help, because it's your education on the line. But we further talk more about that. EMU initiated its disciplinary process against Ward shortly after she enrolled in a counseling practicum course. When she assigned a potential client seeking assistance regarding a homosexual relationship, recognizing the potential conscious issue with the client and knowing she could not affirm the client's homosexual relationship without violating her religious belief, Ward asked her supervisor how to handle the matter. They advised to reassign the potential client to a different counselor. Okay, I'm going to deliberate on that. In a sense, this is a difficult situation, like I said once before, probably for Ward. So I can understand how uncomfortable, again, she was when she had to go through transition when it came to her own beliefs and her trying to finish school, especially towards the end. Ward only had 4 classes left to graduate. The supervisor did try and implement and help Ward by reassigning the client to get help from another counselor that was going through the program as well. Okay, but our codes of ethics on this situation is the ACA ethics states that counselors may not discriminate against clients on the basis of age, culture, disability, ethnicity, race, religious, spiritually, gender identity, sexual orientation, marital status, language preference, socioeconomic status, or basis prescribed by law. It also presents new or expanded guidelines for preventing the imposition of counselor personal values in the life, care, and selection of interventions. Okay, in my opinion, this meant Ward was required to set aside her personal beliefs and values when working with clients during her practicum with dealing with same sex. So that's what the code of ethics was with counseling. Next, refusal and sued. Ward was given the choice of completing a remediation program, leaving the EMU counseling program, or requesting a formal hearing. Ward chose the hearing. As a result of the formal hearing, she was dismissed from the program for violating the ACA Code of Ethics. Ward sued EMU for her dismissal with the backing of the Alliance Defending Freedom, ADF, formerly the Alliance Defense Fund, an organization of Christian lawyers that also assisted in another counseling student's case at Augusta State University that revolved around counseling clients who are lesbian, gay, bisexual, or transgender, LGBT. According to EMU press release, the ADF lawsuit sought to stop EMU from forcing its policies, prohibiting discrimination, and requiring the students in its counseling program to counsel students in conformance with the Code of Ethics of the American Counseling Association. Okay, another thing a code of ethics is saying is a 4B personal values. Counselors are aware of and avoid imposing their own values, attitudes, beliefs, and behaviors. Counselors respect the diversity of clients, trainees, and research participants and seek training in areas in which they are at risk of imposing their values on clients, especially when the counselor's values are inconsistent with the client's goals or is discriminatory in nature. In my opinion, Ward did the right thing and consented her supervisor or advisor in letting another therapist counsel the homosexual client because of her religious belief. So I can believe she was trying to still help the client even though it wasn't going to be with her, and she still sought out to help the client in the aspects of what she was going through. Okay. Ms. Ward asserts that she did not violate any ethical code in referring a client and that defendants require her to affirm homosexuality behavior contrary to her beliefs, religious belief. Thereafter, wrongfully dismissing her when she refused to comply. Defendants, on the other hand, alleged that they did not dismiss plaintiff based on her religious belief, but rather that she violated the ethical codes the university decided to adopt pursuant to its broad powers to determine its curriculum. The parties have filed cross motion for summary judgment, which are presently before the court. Ms. Ward is suffering immediately and irreparable harm as a result of her dismissal from EMU school's counseling program. Her dismissal results in a loss of time and experience as a counselor, and that she is now delayed in obtaining her counseling degree and entering the profession. So yes, like I said once before in the beginning, she only had 4 more classes left with a 3.1 GPA grade point average. So yes, that probably really was kind of tight and put Ward in like a difficult situation and spot, because it seemed like she had to choose between her religious belief and her graduating from school. So yes, I can understand how probably stressful that could have been for Miss Ward. A university cannot compel a student to alter or violate their belief system based on a phantom policy as the price of obtaining a degree. Ward was willing to work with all clients and to respect the school affirmation directives in doing so. The Sixth Circuit wrote that it is why she asked to refer gay and lesbian clients, and in parentheses, and some heterosexual clients. So that means man and woman. If the conversation required her to affirm their sexual practices, what more could the non-discrimination rule require? Surely, like for example, the ban on discrimination against clients based on their religion, one, does not require a Muslim counselor to tell a Jewish counselor that his religious beliefs are corrected if the conversation take a turn in that direction. And two, does not require an atheist counselor to tell a person of faith that there is a God if the client is wrestling with faith-based issues. Tolerance is a two-way street. Otherwise, the rule mandates orthodoxy, not anti-discrimination. Okay, here is a picture I found of Miss Ward, which is state that she won U.S. Courts of Appeal. Appeals courts ruled in favor of her as a student, expelled for adhering to her religious belief, and admonishes university that in parentheses, quote, tolerance is a two-way street. So that is the picture of Miss Ward.